If you recently moved to Florida, you might be wondering what to do with your existing estate plan. Before you throw out all of your existing documents, let's talk about what actually needs to change and what might not. First and foremost, your will is probably still valid here in Florida because we honor executed documents by a non resident if it was valid where you originally signed it. The exception would be handwritten wills. Even if those were valid in your state of residency, they're not going to be honored here in Florida. But for the most part, our state's going to give full faith and credit to things that were done properly elsewhere. And that principle is also going to apply to the other documents that you probably have in place as well. So, a durable power of attorney, for instance, that was executed in another state will be considered valid here, even if it's not done the same way that we might. Same thing for a health surrogate or a living will. But just because documents are valid doesn't mean they're necessarily going to be effective and enforced here in Florida. So, take that power of attorney, for instance. It may be perfectly valid the way it was done there, but let's say it lacks two witnesses like we do here in Florida. Then that power of attorney is not going to work for things like real property transfers, which require those witnesses. And so you're going to have a gap in its effectiveness. Some things also might just be missing from your plan that would be helpful here in Florida. So we have special laws, for instance, about your primary residence here, your Florida homestead. And if your will doesn't address that properly or your trust doesn't say what it should, there can be a conflict there. It can raise problems. Or if your plan allows for things as far as bequesting or devising that homestead that's not allowed here in Florida, then that's going to be a hidden problem that would be superseded by our laws and create trouble down the road. You may also find that the people that you've nominated to serve as, let's say, a personal representative simply won't qualify in Florida because they don't have the right relationship and they're not a Florida resident, that kind of thing. And there's also just a general benefit to having documents that Florida banks and title companies and hospitals are used to seeing. They're more likely going to be able to understand these things and to honor these things without having to send them to a legal department or something like that. So if you have out-of-state documents and you're thinking about updating those, give us a call and we'll tell you what we would suggest and what you might want to change and what you can keep.